City of Stevens Point Public Protection Committee meeting, recorded Monday, May 13, 2019.
We'll call to order the Public Protection Committee at 7:03 on Monday, May 13th, 2019. First, we have a quorum and Alder Dugan is excused. The first item on the agenda is discussion and possible action on the following: appeal of notice service charge for property maintenance violations, 517 Washington Avenue. Is anyone here representing that property?
Sean Wolf. Chief is checking outside, I believe, as well.
Just in case.
Thank you, Chief.
Any comments from the audience? Members of the committee?
Well, it looks like in the communication from Mr. Wolf that the items were not accumulating, but rather being moved around. And so I guess I am interested in approving his appeal, as it seems that the communication about what was actually being violated was perhaps not actually being violated.
Well, I would like to say I have a concern of the fact that this was back in November and contact, and I understand that it was his parents, but if the parents owned the property in November and they got the two notices, I am concerned that it wasn't brought forward until March of 2019 by the person that was living there, their son, to see if he could appeal the fine. That's an awful long amount of time to bring this forward, and I don't think that the reasoning that we have ordinance for a reason. One of them is because if you have furniture that's not made for the outdoors, we have had problems with critters burrowing into overstuffed furniture. The wooden chairs, I don't think would have probably been the issue, but the recliner definitely is, and there's a reason why we have those for an ordinance. The two things right there tell me that there should have been some conversation prior to this, and he's got a lot of different excuses in here, but I feel that just because it's brown and recliner and it blends in with the house, so it's not, shouldn't be something that was unsightly, is not really valid.
I guess the concern that I raised in the discussion of this item is that the communication from Mr. Cordes about that clearly was not clear enough for the property resident, and he thought they were talking about one chair and not the other, and he was moving that one on and off, so it was not there accumulating. And I guess when he talked about the wooden chairs, there's lots of people who have wooden chairs on their porch, and so determining whether or not it's made for interior or exterior, I guess perhaps we need some further clarification in the ordinances about that.
Oops. Go ahead.
Well, so I just want to point something out. It says that they were moving things around, but if you look at the picture from November 16th,
Yep.
and then again at the picture from November 19th, December 3rd, re-inspection, December 3rd, the one with the snow on the ground,
Right,
nothing looks moved.
not at all.
So I don't understand, it would be nice to have the applicant here, but it doesn't look like anything was moved around. As a matter of fact, it looks like at least two of those chairs, the wooden chairs and the table, were there as a fixture. They're arranged such that it's not like a quick storage or moving in and out. And what appears to be the recliner, I can't see the vacuum cleaner, but the recliner doesn't look like it moved at all. As a matter of fact, the bowl of something that was there in November is still there in December. So I would just submit that for your observations.
I'd like to move to deny the appeal.
I'd like to second that.
Director, we have a motion and a second to deny. Director Ostrowski, did you want to say anything before we vote?
That is correct. The materials remained outside even after the second letter. Furthermore, not only did we provide notice to his parents in Ohio, we did send a letter to the tenant at the property.
Thank you. Any more questions from the committee? From the audience? Okay, we have a motion and a second to deny. All in favor, vote by saying aye.
Aye.
Opposed?
Nay.
Vote carries 3-1. Next item is 1320 Main Street. U.S. Post Office.
No one is immune.
Nobody.
And I did receive an email from Postmaster Graham that he would not be attending the meeting tonight.
I did see that. Did everybody on the committee receive that email? Okay, so,
I move to deny the appeal by the post office.
we have a motion to deny. Do we have a second? Okay,
Second.
second by Alder Nabel. Any discussion?
I do want to make a comment, because earlier at a previous meeting, we were talking about accessibility and those issues for people with mobility. This is one of those examples, and that's the reason we have the ordinance to clear the snow from your sidewalks. We allow 24 hours after the snow stops falling if you have a boulevard. If you don't have a boulevard, it's a little more of an inconvenience, so we allow 72 hours. And that's important not only for people who have mobility issues, but just general public. I talked to a person today who said that this past winter in a certain area of town, they saw people walking on the road. Why were you walking on the road? Well, they looked and the sidewalks hadn't been shoveled. With the big snows that we had, it was difficult for those people to even walk on the sidewalk, so they chose the road, which makes it extremely dangerous, which is the main reason that we have these sidewalk clearing ordinances in place.
I also have a comment. I'm looking at the case referral that was included in the packet. And the individual went into the post office and was told that the city was responsible. Well, the city took responsibility, and now it's going to cost the post office some money. So we have a motion and a second to deny. Any other comments from the audience? Okay, all those in favor vote by saying aye.
Aye.
Aye. Opposed? Motion carries. The third appeal is for 1901 Prairie Street. Is anyone here? Come up to the podium and state your name and address for the record, please.
Okay, I'm Jonathan Fredrickson, and I live at 1901 Prairie Street. If I just go on. Okay,
Please
well,
do.
I'm new to
Yes,
this.
state your case,
I'm new to
please.
the city of Stevens Point. We just moved here in February from Amherst. I bought a house on Prairie Street, kind of over by the paper mill, and we bought it from some not so great people. And just when I thought I had it all figured out, I got a letter for snow removal from a date before we even owned the property. But I just want to state, like, we have all their back taxes paid. They had a bunch of other citations paid. We stuck a lot of money into the house, and then that was kind of just a little, cherry on top of the sundae. So, but yeah, this was before I owned the house, so I really don't really know how to fight that. Besides we didn't get anything after we took ownership, so that's all I got.
Okay. I'd like to ask Director Ostrowski a question. Primarily about the title company. Is there any way that we can bill them or,
So just to give some background on the situation, and I don't think anybody disputes that the snow was removed, it was in violation. The situation came where the order was issued prior to them taking over ownership of the home. They did a title search prior to purchasing the home, did not discover anything because the order was issued after they did a title search. There was about a month in between the title search and the closing on the property. Typically what happens there is the title insurance, or title company will provide gap insurance for these types of situations where that is covered under their gap insurance. Just think of it a similar situation where all of a sudden a lien gets put on the property during that 30 days, and you may not have rights to that property if that lien is put on, and that's what that gap insurance is there to cover. So,
Thank you. Any questions for the director?
Well, so if we deny the claim, this person has the opportunity to go to the realtor or the title company to recoup
so the
that
way this
money?
situation goes is, right, so right now, if it's not paid, it goes on the property tax roll. Unfortunately, this owner is now the owner of that property and would be responsible for that charge. It would be up to the title insurance and the purchaser, now owner of the property, to discuss the terms of getting that fee refunded through the title company.
I guess my point, if you look in the ordinance about snow and ice removal, it says that the owner or occupant is the one that needs to do it. And so this individual is neither the owner nor the occupant at the time. And albeit we don't want to chase down the prior owners because that's not really a sound way of working.
Using
But,
our time.
I guess I would move to approve this appeal.
I would like to second
Okay.
that.
We have a motion and a second to approve the appeal. Any questions? Any comments, questions from the audience? Okay, so we have a motion to approve the appeal. All those in favor would vote by saying aye.
Aye.
Opposed?
No.
Vote 3-1. The ayes have it. The appeal is approved. And,
I want to point out, if I may, Madam Chairman.
yes.
Thank you for taking the time to come here in person. And sorry this happened, but we're glad you chose Stevens Point.
Yep. Yep.
Yeah, considering everything else you've had to pay for the property, I think this one we could let slide.
Yeah. Well, it's bad.
Appreciate you bringing a property back. Okay, so the next one would be 833 Pulaski Place with 2 violations. Anyone here from that address?
Samantha Denenberg is the name.
Okay, anybody might be outside?
Nobody's here?
Nope, okay.
I move to deny the claim.
Chair, I would be wondering if we could separate the 2 appeals out as separate votes. Their unique situations.
There's only one appeal here,
Can we do
right?
that if it's listed as one?
Yes.
Oh,
Because I
okay.
have it listed as 2 separate dates
Items.
on there.
Do we need a motion for that?
Nope.
Oh, okay. Well, let's go with the first one first then, per Alder Dalton's request. So that would be,
Move to deny. Item 1.
From January.
And that one
Second.
is from January 29th.
okay, so we have a motion to deny. Do we have a second?
Yes.
Okay. So we have a motion to deny the order of, on January 29th, 2019. All those in favor would vote aye.
Aye.
Opposed? Okay, that appeal is denied. The second notice was, let's see,
March 11th.
March 11th, 2019.
I would make a motion to approve this appeal. The individual sounds like they attempted to move it, and in our ordinance, it says if the ice is unremovable, that is part of the ordinance, that if it's unremovable, they're not, so.
Okay, we have a motion to approve or uphold the appeal. Do we have a second? I will
Is this
second
only,
it.
is this the only, on the second one, was it only about ice? It says snow and ice. So were they also looking at the fact that there was
Doesn't make a
snow?
difference, does it?
Snow covered sidewalk. Director Ostrowski?
I can understand when there's ice. The reason I wanted to answer that was because when people walk on it before you can get out there to shovel, even if you get up really early, it gets iced like that, and it's packed down. It's very hard, and I know that because we have to try really hard living near the university. And the second thing is that, if it was for ice, I would say no, that we shouldn't be charging them because it is shoveled So I just want to know if they're saying it wasn't shoveled enough, or what was it?
So with the second violation, you can see it's on page 26, and no, it was not shoveled. There's still snow on the sidewalk.
Is this also part of it, the picture that we're looking at, is it also on the other side of the driveway there, part of that sidewalk? That belongs to that on 311?
Correct.
So that isn't shoveled then.
It's hard to tell from the picture. I would think that it would be the one in front of the house.
You can see, so on page 26 will be the before,
Yep.
page 27 will be the after.
This part.
You can see it goes all the way through.
Yeah, it does look like the neighboring people did up to that part, and then it was not shoveled over in that area. So I would move to say that it was not removed on that date.
We already have a motion.
No, there was no
Okay.
second, was
Did
there?
we-
There was no
was.
second.
no
Oh, there was?
I seconded,
Oh, I didn't hear that, sorry.
so.
I'm
that's-
sorry.
Mayor, you had a comment.
So, yeah, it sounds like it was gonna get a little unusual here. Let me just point out that you have a motion and a second, so we need to address that motion first.
Okay.
If you are in favor of the motion, you'll vote yes. If you're opposed, you vote no. You have a unique situation here because you don't have your fifth. A tie results in a failure, which means that the motion to approve the appeal would fail. So effectively, a tie also means that that fails. I just want to point that out.
That's actually a question I was gonna ask, should we go 2-2 here? What the next step would be.
There is no next step.
Okay.
It fails.
Okay. So, given those circumstances, a failure to attain a majority would, in effect, depending on which way it was, the motion would fail. So all those in favor of upholding the appeal,
Wait a minute.
denying the appeal?
No,
The
approving the
motion was,
appeal.
To approve the
motion was to
appeal.
Okay, approving the appeal, would vote aye. All those opposed to approving the appeal would vote no.
Correct.
Yeah.
No.
Okay, so,
it's,
so call for it.
No, we have to ask.
okay, so
You were explaining the vote, you didn't ask for the vote.
Oh, I'm sorry, okay. I thought I did.
No,
Okay, so all those in favor of upholding the appeal would vote aye.
Aye.
Do we need a roll? Is that one vote or two? Just one? Okay.
just one so far.
All those in favor of not approving would vote no. No.
No,
No.
So that's three.
Okay, vote. I got you. So with that, the motion, the appeal is denied. The next item on the agenda, thank you for bearing with me, as we work through the peculiarities of Robert's Rules of Order. We have a license list. I would say we can take them all as a group. Chief Skibba, do you have any issues with any of the candidates?
Regarding the license list, number
Class
2
B.
license list, A and B, no.
Okay.
Move to approve the licenses.
Okay, and we have a motion to approve and a second. All those in favor, vote aye.
Aye.
Opposed, vote no. Ayes have it. License list is approved. The next item on the agenda are the temporary Class B and Class B picnic licenses. Always a good thing to vote on, because it makes you realize how many great things we have coming up in Stevens Point.
Move to approve the temporary licenses.
We normally would read everyone, so it's kind of an advertisement for them.
Yes, I intend I do intend to read them out, because I think it's important for folks to know. We can take them all as one vote. The first one, St. Stephen's Parish has applied for their picnic license to be held on June 16th. Create Portage County has applied for a Hmong Week celebration on May 18th at Piffner Park. St. Joseph's Parish has applied for a picnic license for June 1st and June 2nd. Definitely go out and check those guys out. Stevens Point Alliance has requested a license for Rock the Dock on June 15th. And St. Stanislaus Holy Name Society has applied for a license for their steak feed on August 13th at Buchholz Park. So we have a motion, I believe, to approve, and a second by Alder Nabel. Those in favor would vote aye.
Aye.
I'm sorry, my bad. Comments from the audience? Still getting this down. Do I have to say that 3 times?
Nope.
Comments from the audience?
Nope,
Okay.
only on
You say 5.
public hearings. Public hearings and nominations.
Okay, so we did have a vote of aye on that motion, is that correct?
Correct.
Okay. The next item on the agenda is a secondhand article dealer for Eco ATM LLC, Barnes Canyon Road, San Diego, David Macara, owner at 1500 Pinecrest. Chief, any comments or concerns?
No, reviewed the application and no concerns.
Comments from the audience? From the
Well, is
committee?
there, that's a long way to drive every day, Canyon Road, San Diego.
It is a Dropbox situation where they have, you submit your phone, drop it in the Dropbox, and then they mail you a check later. There are several other municipalities in the area, including Wisconsin Rapids, that this company operates in. And the police department checked with the detective bureaus in those jurisdictions, and things have worked out just fine.
Okay,
What-
what's the location of Dropbox?
The Dropbox is going to be at the former COPS, the Metro Market,
1500 Pinecrest?
1500 Pinecrest.
And what are the drop-off items?
Oh, way out there.
Phones, cell phones.
Cell phones.
Cell phones?
Okay.
Cell phones. So if you have an old cell phone you want to get rid
Yes,
of and you
I
want to
do.
get paid for it,
Lots of them.
there's a Dropbox where you can get
Thank
some
you.
money.
If I may, so yeah, sometimes people will buy, companies will buy your old cell phone, sell it for parts or on the secondary market. There's also other alternatives. There's a drop-off at the police department. I know that the women's shelter uses those because 911 will still work even if it's not active.
Okay.
And they take donations of old cell phones as well. But if you're up to getting some money for it
No.
and you approve this, the Dropbox would be at the former COPS location at 1500 Pinecrest Avenue.
Thank you. And thank you for clarifying other areas, because that's nice to know.
I'd move for approval
Interesting.
for this license then.
Do we have a second? Okay, we have a motion and a second to approve. All those,
Wait, I have a question about the former cops.
Yes. It recently transitioned, I think Kroger bought it out.
Kroger
and
bought
Oh,
it
you're not
is-
they've
talking about
renamed
the
them.
one way out
Oh,
on
not the
Highway
one-
10?
No, no,
I was thinking
no.
the same.
The one-
1500
yeah.
Pinecrest
No.
is the one on Main Street.
Park Ridge.
Behind.
Park Ridge.
well,
It's in
Yeah.
Stevens
It's
Point.
in the city of Stevens
Thank you,
Point.
Alder.
Across the street.
District 7,
Oh, a
Okay,
little
thank you
plug
for the
there, huh?
clarification.
so that seems like a pretty safe location, a lot of traffic there at the cops parking lot, so. So
Oh, you didn't call for
we
that?
have a motion and a second. Those in favor vote aye.
Aye.
Aye. Opposed, vote no. Okay, motion carried. We have a request to hold an event, a street closing, which I believe is our first permit for one of our parklets by Bria Bella and Company. They're going to have a couple of events on June 1st, and they've requested the use of a sidewalk and 2 parking spots in front of the store.
Just to be clear, this isn't a parklet.
It's not under
And
that
it's
ordinance?
it's under the street closings, event holdings, even though we're not closing Main Street.
Right.
Okay.
Because
By
we're
statute, yeah, by statute, the mayor has the authority to just give them a parking spot to use for their celebration. But I thought it important that we bring it to the Public Protection Committee to make you aware of it. It is a recurring event. They had their first anniversary party last year. They're having their second anniversary party this year, albeit very similar to what a parklet would be.
I was gonna say.
This doesn't fall under the parklet ordinance that was recently created. This is just a celebration of them turning 2 on June 1st, 2019.
If there's nobody, I'm sorry, quick.
I just have a quick question to ask. So with the parklets, they pay a fee to be able to do that, correct?
I'm going
We
through-
can't go there.
So,
I think if it's for the public,
if I may, Madam Chairman.
yeah,
Again, keeping the decorum going through the
Yes.
chair. Yes, the parklet does have a fee, however, that is a season-long
Got it.
opportunity.
Thank you.
This is
Just
a
wanted to
one-day
clarify it.
event.
Good. Thank you.
I'd like to make, if there's nobody here to speak on behalf of this request, I'd like to make a motion to approve.
Second. Go ahead.
and we have a motion and a second to approve the request to hold an event and street closing. All those in favor vote aye.
Aye.
Opposed, nay? Okay, ayes have it. And number 6, we have Class B, it's a 2019-2020 Class B beer and liquor applicants, Class B beer and liquor winery, Reserve Class B beer and liquor, Class B beer and C wine, Class B beer, Class B beer, that's the most times I've probably said beer in my life. 6-month license, Class A liquor and Class A fermented, and Class A fermented license applicants. There is quite a lengthy list in the agenda packet. Chief, any issues with any of the applicants, any of the license renewals?
Fortunately, this year we can say no.
Good. Any questions?
6-month application. I thought they were for a year.
That's just one special case for that business.
Oh, that's American Legion.
American Legion, they only use
Baseball.
it for the summertime.
For ball games. Thank you.
Anybody from any of the organizations here? Anybody want to speak from the audience? Okay, committee members?
And just so you know, the ones with asterisks are the ones that have changes from last year
Thank you.
on the list.
Okay. So we would entertain a motion to.
Make a motion to approve the
Okay.
license applications.
And a second? Okay, have a motion and a second. Those in favor would vote by saying aye.
Aye.
Opposed, vote by saying nay. Ayes have it. The last item on the agenda is a discussion about city council and other governmental bodies attending meetings and open meetings law. I know this is something that many of us have wrestled with on the council. We have public information meetings, like the building committee for the county and the Division Street Vision for Stanley Street. And they're public information meetings, but yet we run afoul of open meeting laws if too many alders attend. I think this is a timely discussion. None of us want to break the law. And I think we all do a pretty good job of not getting in trouble with walking quorums and open meetings. On the other hand, we have a right to know as citizens about the information that might be presented. Although you can watch a video, you don't often get a sense of the tone in the room just from watching a video. So I would open this up for discussion first to the committee and then folks and our city attorney as well. I know he's very diligent about letting us know what path we need to walk. So, and I appreciate Alder Jennings bringing this forward. Anybody have any comments?
I'd bring up one, and that is,
first.
you know, I remember back in 2018, prior to Christmas, we had a notice given on one of our agendas when we were having our holiday party, and it said, "Public notice is hereby given that a quorum of the City of Stevens Point's Common Council or any committee thereof may attend the following," and then it's the holiday party, Monday, the date, and where at. So I'm I am wondering why we weren't able to go to the retirement for Director Schrader, sorry, I always do that. Schrader, because that would be a walking quorum, and I felt I was frustrated because we did at one time, were able to do this, and it seems like it's been a back and forth on that kind of a question. That one was definitely public and just a holiday or celebration thing, so it was social, which is allowed. But we were also then told we couldn't do that either. So on top of that, I also feel very strongly about the fact that I've not been able to go to any of the open meetings for Division Street, and the changes, anything that has been informational. I wouldn't care if I was told I couldn't speak there. I'd be fine with that, but I really would like to hear individuals speaking about what they thought. And it's very hard to do that by watching a video when people are in groups. So I would really hope that we can look at this and see if there is the clarity there. And what I feel Alder Jennings' letter really does prove the difference between what is a walking quorum or a quorum, that as long as we are putting it in the public notice that there might be, we should be okay.
Alder Jennings.
I'm sorry, I guess I'm jumping ahead, but I feel like there needs to be more context to this, since I wrote the memo. And for the public, I wrote a extensive memo. It's in the packet. Anyone can read this memo, and it's been available since the packet was released. I also asked the clerk to send this memo to all alderpersons, as well as the mayor, the attorney, the clerk, Director Ostrowski, and President of Council. So this is a long overdue conversation. The background for me, researching this, I spoke with Alderman Madison, which then prompted me to contact the League of Municipalities. I spoke with Maria Davis and Clara Silverman. I spoke with the district attorney. I spoke with the Department of Justice. I read a number of articles about this. So I did quite a bit of research before I wrote this memo. And the memo is very detailed. Again, I'm not going to read it because it's quite long. But the context of this is open meetings. It's not walking quorums. It's open meetings law and what open meetings law actually means and what it doesn't mean. And just real quickly, I state in here, open meetings law does not prohibit a quorum, but instead asserts that all official meetings where a quorum is present must be properly noticed. This notice informs the public about the content of the meeting, where it will be held, and what role the government body will have during the meeting. In this way, the public may decide to attend the meeting or learn more about what took place, which is the purpose of the law. We need to think about what is the spirit of the law itself. I then propose 3 things. First of all, we have awareness, in other words, knowledge about what these laws are and what the statute actually says. I then recommend procedure and then action. In terms of procedure, and this comes from the recommendation that I pulled together from all the people that I spoke with, it's pretty simple. If a member of a governmental body, and council members are members of a governmental body, wish to attend a meeting where other members might be present, we simply notify the clerk that we're going to do this. If the clerk tallies up enough people, sufficient number of notifications that constitutes a quorum, then the clerk will notice the meeting. And there is a procedure for this, and certainly the clerk knows this. It must be noticed 24 hours prior to the meeting, but the clerk I would ask him to tell us how far in advance you need to know these things for you being able to notice things properly, because that would fall to us. The recommendations I also received in talking with people is not to use boilerplate language. A quorum might be present. That's not appropriate. The bad key piece that I included, that isn't directly related to what I'm talking about, but it gives one example of how to notice I think the city attorney would be happy to work on language of something that would be appropriate. And the action is simple. If a city council member becomes part of a quorum at a meeting or a quasi-meeting, they turn around and walk out of the meeting. It's as simple as that. But we should not be marginalized. City council should not be marginalized and told and insisted that we cannot be in public view for fear of forming a quorum. And that is not what the law is about. And I am embarrassed to show up. I have been at the public information meeting on property exchange, and I did attend the conversation on future of downtown and Division Street. And I was embarrassed that only 1, 2, or 3 of us as alder people showed up, and we were told you can't be there as a quorum. So I was one of the few who was there. The public is there probably wondering, well, where is my alder? And if I was not an alder and I went to one of these meetings and my alder wasn't there, I'd be saying, where the heck is my alder? Why isn't my alder getting this information? So I think we're doing a bad job of representing our city when there is this sort of overextension and overinterpretation of open meetings law in a way that's twisting it to be something other than what it's meant to be. It's not meant to keep people from attending meetings. It's meant that the public knows there's going to be a meeting where a quorum is present so the public can make the decision to be there or not. That's what my understanding of the law is. So thank you for giving me that moment to provide some context. Again, the memo is in the packet. Thank you.
Alder Shore.
Thank you, Chair. David Shore, 2nd District Alder. It sounds like we have a ready-made solution to work with here that's just going to take more coordination. If I'm understanding right, we just need to sort of take attendance in advance or figure out who wants to go to which meetings, and then from that you see whether that represents a quorum of the council or a quorum of one of the committees. I mean, the one clear recollection that I have of this issue was the big meeting that we had on campus about parking, and which I guess is a reminder of the point that we need to coordinate amongst ourselves about our plans to go, and also be aware that if we're there as a quorum and then all of a sudden we're not a quorum because somebody leaves. I remember that we had to end the meeting kind of precipitously right there and then because I guess one of us had left. So it seems like that's the sensible answer, and I'm not sure actually whether anybody would probably disagree. It's just going to be that much more sort of on us to make our plans. And I guess the one point of information question is the one that was raised before us. Well, then, in order to notice, then how far in advance do we need to make our intentions known? Thanks.
President Johnson.
Thank you, Madam Chair and members of the committee, and thanks to Alder Jennings for meticulous research on that. Couple of points. I'm used to, I've worked in government now for almost 20 years and posted enough agendas to kind of fill up this room. When we had the grand opening, believe it or not, we had a grand opening for a landfill. Yes, we did. We cut a ribbon and the whole thing. Hey, I love my job, so. But we invited the entire county board, and we did survey the county board to see if we would have a number, how many we would have coming, and it became apparent that there was a lot of interest, mostly because we had food, I suppose, which would not come from the landfill. It was catered in, yeah, but, and it was exciting, the first landfill in the state of Wisconsin in the 21st century. And we did post it that there was going to be a quorum of, the language, Corporation Council came up with the language, I didn't. And we posted it, and we indeed had, I don't know, what did we have, 25 of the 38 county board members there, and then there were quorums of committees, et cetera. So that's the point, and that's what I'm used to, is that kind of deliberate tactic of making the public aware that, you're going to have policymakers there, but nobody's going to be making any decisions. They're going to be enjoying the food, as we did at the holiday party, or taking in information on important topics. I think the other example, in addition to the holiday party, I remember being at the League of Wisconsin Municipalities conference that was held here in Stevens Point. We sat around the table, and I think it was Alder Kneebone, and it was Alder McComb, and me, and Alder Oberstadt. I don't know if Alder Jennings was there, but there were a lot of, the mayor was joining us, and we all sat around and enjoyed the luncheon and the speakers. And then I think you left our table and went up on the podium or on the stage. So there are a number of situations where we do gather. These are not decision-making times. One last comment, excuse me. The Division Street corridor discussion, the North Division Street corridor, that discussion that happened at the rec center the other evening, I did show up. I stood, I didn't enter the room. I felt weird because of this, black cloud hanging over my head. But interestingly, one of my constituents was there, and as she was exiting, she goes, "Oh, it's so good to see you here. This is important stuff." And then we took a moment to chat about what she had thought and her decisions on what she thought that should look like. So these are important times, and I'm hoping we can find an amenable situation. I think what's laid out, what was provided by the League of Wisconsin Municipalities does provide us a path. So thank you.
Anybody else from the audience? Logan, did you want to say something before we close it off here?
So I read through Alderperson Jennings' memo, and I won't go too much into detail about just my thoughts on the particulars in it. There's some things in it I agree with, there's some things in it I disagree with, and some things that are subject to some debate and interpretation. I mean, there's a reason that there's a fairly lengthy manual for this type of stuff, and that there are court cases, and it's not crystal clear, and there's a lot of different scenarios that can happen. But one thing I absolutely 100% agree with is when she says, and I'm chopping up the sentence, the city attorney may advise the council, but does not have authority over the body. The boss is the population, not the city attorney. I am not the council's boss. I'm here to give you legal advice. I hope I do that well. But if you disagree with me about something, you can make your own decisions. And if you guys want to go to a meeting, you can go. But I guess just, be advised that if I've provided an opinion, whether in public or in private, that says that could constitute an open meetings violation, just be ready for that conversation to come up and be aware of how I might have to answer questions about it if I'm asked what my thoughts are on it. Now, all that being said, I don't think that we're dealing with a situation with these types of meetings where open meetings laws prohibit council involvement. What they do is require us to work within a certain set of parameters. And there are a couple trade-offs to that. One of them is just a little bit of tedium in terms of making sure that we've got some boxes checked and some notices out. The other is that you do lose a little bit of flexibility in the manner and method in which you conduct the meetings. And the example that I've mentioned a couple times when talking to people about this recently is way back, this must have been 4 or 5 years ago, we had our parking study. And when we had this sort of initial presentation by the consultants for it, it was in a big room over at the new Mid-State, and they had sort of a number of kiosks set up around the room. And people came and sort of milled around from one to the other, There were a couple staff members from city departments, a couple staff members from the consultant there, and you had a whole lot of individual conversations going on, which is great. That's a great format for people to get information about what's happening, for everyone to have a lot of conversations about which particular aspects of it are important to them or their personal concerns. But I think that if you were going to notice something and say, this is a meeting of the Common Council, and then conduct it in that way, you might run into some problems. Now, it's possible that within that, every single conversation stays on topic based on what the agenda said that the meeting was going to be about. And there, at least you've got, I guess, an arguable level of compliance with the notice provisions. You know, you kept it within the confines of what the notice said, which can be fairly broad. But I don't think anybody would look at that and say that that looks like a good, orderly council meeting. You know, the way that the meetings are run, you know, there's another thing in here that Alderperson Jennings said that I totally agree with, sort of. It says, Robert's Rules of Order and not open meetings law establish that a quorum must be present to convene a meeting and transact substantive business. I agree, the open meetings law isn't what says that you have to have a quorum. But Robert's Rules isn't necessarily what says it either. What says you have to have a quorum is Chapter 62, specifically 62.11 sub 3, which is 6211 is the part of the statutes that creates common councils. And there it says a quorum is 2/3 of the members. And a quorum is a word that you would just look to the dictionary definition for. It's just, this is the minimum amount of members of this body that have to be present to transact business. And common misconception is that, you know, a lot of times people think that just gathering information and not voting on things or making decisions, they think that that doesn't count as transacting business. But the law is pretty clear, the courts have been pretty clear. If you're gathered together to get information about things within your purview, it constitutes transaction of business, and that does result in a meeting occurring. So I think that going forward, what we might want to do is just look at what format are we using for these meetings. And certainly the process here of just sort of communication to find out how many people want to attend, you know, absolutely. I mean, if you don't have to put out a notice that's in compliance with Chapter 19 and follow all those rules because you're just not going to have enough council members there, great, no problem. But if we find out that there are going to be enough, just put out the notice and follow the rules and act accordingly. Now, one of the tricky things, though, is that the thing I mentioned about quorum, 2/3 out of the statute. The numbers test under the law for whether or not you have enough numbers of members for it to constitute a meeting and trigger all these things, that number is a different number than the quorum number. There's a gap in between. And you can even have negative quorums, which can be numbers smaller than a majority. Now, granted, that's usually for fairly special circumstances. Things where you need a supermajority of votes, you can have a negative quorum that's smaller because an amount less than half can be enough to block the action. You know, if you have to get 9 votes of the council, then only 3 people can stand in the way of that. But that's going to be pretty unusual. However, the numbers test, if you have 6 members, you've triggered it. But we have to have 8 members for a quorum. So if we found out that we had 6 or 7 members who wanted to attend something, I think that's where we're going to run into the pinch, which is we have enough that it satisfies all the tests for Chapter 19, but we don't have enough for a quorum. So you can put out a notice there saying there's going to be a special council meeting, but then you don't have enough people to hold it. Now, maybe we just have to look at that as, well, that's a scheduling issue. You know, if we don't have enough members for it to hold a special council meeting, we look at a different date and figure out when we can make it work. And I think probably one of the trickier things, and if you look at something that's in common among a lot of these different meetings, is that they can be things where we do have the consultants coming in because it's, you know, somebody who's putting together the design study for Division Street or the parking study that I mentioned earlier. Or it's a joint thing with the county government, like the one that was mentioned earlier. So you just start overlapping all these different scheduling issues, and it can become pretty difficult to find a day that works for everybody involved. So I think that the ultimate issue here isn't necessarily a huge disagreement over what the law says, but just the normal struggles you have with trying to make things work from a calendar perspective and a practicality perspective. And I think that those are all surmountable problems, but we just have to be willing to, do a lot of doodle polls and stuff. And that gets annoying sometimes, but obviously we can make it work. And if it means that we have to curtail the format of those meetings a little bit to make it more of a one conversation going on with, at least somewhat structured, a chair, maybe not necessarily a chair who's, being the guide for the conversation, but something where it's not a whole bunch of individual conversations going on all over the room. Just so that, somebody who's there is seeing all the information and not, oh, I missed out on the conversation that my alder had with the consultant over there because I was talking to somebody else. And now I don't know what information that person's been listening to. So that's basically all my thoughts on it. And I certainly look forward to finding a way to satisfy what everybody wants to do here, which I think is well within reach.
Thank you. Do you have, anybody has questions for our city attorney?
Total confusion. Total. University meeting.
That means I've done my job
Yes,
perfectly.
thank you. Alderman Shore mentioned the university meeting about the parking. If you were to call a special common council meeting or recognize it as a meeting, that means I would have had to go, even though it's not in my area. I wouldn't have had to show. Did you need a quorum when you
We
recognized it?
did notice that as a council meeting, did we not?
Well, I just used that example, but I'm saying it's no concern of mine. I'm way on the other end of town. It's a neighborhood issue. But you recognize that I have to show up for that meeting?
Mayor Wiesen may have an answer here.
Sure.
Okay, and there are a lot more facets to this. Logan put a lot of them very well. So going back to that example, we noticed it as a council meeting because we had 8 people that said they would attend. We took a poll, and 8 people said they would attend. I actually advised against having it as a regular council meeting because some of the people had to say, okay, if you need it for a quorum, I'll come. And that's exactly what happened. One of the alders had to go to work and left, which means we lost our quorum, and therefore we could not continue the meeting. There's a big deal going on in Rhinelander right now where the council was convened or attempted to convene. They didn't have a quorum. They couldn't have the meeting. Because we lost that quorum and it was noticed as a meeting, we couldn't continue the meeting, so then we had to stop that
But
meeting.
even though it's an informational meeting and no decisions are made, it's under the same category?
As the city attorney just said, if information is being gathered, and your words are much better than mine, but if information is being gathered, it constitutes conducting business. So in this case, yes. You, however, as an alder, have the choice, just like you do with any other council meeting or even a committee meeting, to attend or not attend. There is state statute that allows the chair, in the case of council, it would be the mayor, to compel you to attend. That means I get to talk to Police Chief Skiba, and he sends someone to your door, picks you up, and brings you to the meeting so we can conduct business. I can't think of any time that's ever happened, nor any reasonable circumstance where that would happen, but that's the only recourse. So if we notice it as a council meeting, we must have a quorum.
Yes.
If we do not have a quorum, the council meeting cannot be held. If we do not notice it as a council meeting, we cannot have the quorum or what Logan was talking about with the majority to conduct business or whatever it was. He talks about that 6 or 7, that gray area of any of the council. If we do have that many, we could be seen in violation of open meetings laws because we had too many people there and it wasn't noticed. Now, the way, sorry, I gave 4 examples. I'm going to go over them again. If we notice it as a council meeting
Yeah.
and we get enough people, great, done. As long as we comply with the agenda specifics outlined in the statutes. If we notice it as a council meeting and we don't have a quorum, we cannot have that meeting. On the advice of the city attorney, and if I'm wrong in your opinion, correct me, please. Now, that's if we notice it. If we don't notice it, and we have a quorum, or in this case, you said 6 or 7, we could be seen in violation of open meetings laws. If we don't notice it, and we don't have that 6 or 7 people show up, or a quorum of any committee, then we're good.
I just want to quote something here, going back to earlier point. This is straight out of the manual from the AG's office. This comes from the Badke case, which has been referenced a couple times, but it says, the court stressed that a governmental body is engaged in governmental business when its members gather to simply hear information on a matter within the body's realm of authority. The members need not actually discuss the matter or otherwise interact with one another to be engaged in governmental business, which that aspect of it comes up all the time. It doesn't matter whether action's being taken or not. Now, I heard Alderperson Jennings make a comment just now. I think what you were saying is that if something is noticed as a meeting and then you don't have a quorum, the mayor said then we can't hold the meeting, and you said that's not true. So I'd like to hear what your thoughts are on, because my understanding of it, it says in 6211, a quorum of the council is 2/3 of the members. And just the regular old dictionary definition of quorum is what I think you would look to there. And that says this is the minimum number of members you have to have in order to conduct business. So do you want to comment here?
Yeah, but we're not conducting business.
Yeah, thank you very much. So I ran this particular scenario past a number of individuals, and I think I tried to pare it down to the way I could understand it best. So again, the spirit of the law is that the public knows a meeting, quote, a meeting according to certain statutes is happening. And for there to be a, quote, meeting, what triggers that is there's a quorum of a body who makes a certain set of decisions related to the content of that meeting. So if it's noticed that that a meeting is happening, it's automatically assumed that there's a quorum, because that's the purpose in noticing the meeting. Let's give a number. The number is 8. If 8 people show up and the meeting is noticed, that's fine. If 7 people show up, there's not a quorum. There's no conflict. You don't have to stop the meeting because there's not a quorum. I ran that past the DOJ and other people, and they just said, that's not true. You don't have to stop the meeting. Here's another statement from, again, and this is also mixing Robert's rules, I think, with open meetings. This is specific to this issue of do you have to stop a meeting. Once a quorum at a meeting has been established, the continued presence of a quorum is presumed to exist only until the chair or any other member notices that a quorum is no longer present. If the chair notices the absence of a quorum, he or she should declare this fact, at least before taking any vote or stating the question on any new motion. Any member noticing the apparent absence of a quorum can and should make a, quote, point of order to that effect whenever another person is not speaking. It is dangerous to allow the transaction of substantive business to continue in the absence of a quorum. Although a point of order relating to the absence of a quorum is generally not permitted to affect prior action, if there is clear and convincing proof no quorum was present when business was transacted, the presiding officer can rule that business invalid, subject to appeal. So I guess I disagree with the parking meeting, although I do defer to the attorney on this. There was not substantive business taking place at that meeting. According to this statement from Robert's Rules website, that meeting did not stop. But again, back to what I have been, the interpretation given to me by the DOJ. If there's a quorum and it's the substance of the meeting is within their purview, it must be noticed. If that quorum doesn't show up, that doesn't mean there's no meeting. For example, this was the example given to me. a quorum of a body might show up to a conference, right? And let's say 7 people show up and the 8th person, their car broke down. They don't stop the conference, do they? Because of that. That was the analogy given to help me understand this, and that's what helped. So thank you.
That's something that's been very confusing for me as well. If it's noticed as a city meeting and a quorum doesn't appear, then the meeting can't happen. But these, maybe as our attorney said, maybe it's the way these meetings are put forth that we need to clarify. I usually defer to the alder whose district it affects and stay away for that reason, but there were times I really would have preferred to be there, but didn't want to run afoul of the law, so.
I just want to touch on something that Tori was just talking about. In my view, there's not really anything in Robert's rules that is pertinent to questions of open meetings compliance. Robert's rules is there to say, here's what you do once you're all together to exercise this authority. Saying it, somebody notices that a quorum is no longer present, it relates to the validity of actions that were attempted to be taken. That's different than compliance with Chapter 19 of the Wisconsin statutes. I mean, Robert's rules, there's all sorts of private organizations that operate according to Robert's rules, but they don't have to operate in accordance with Chapter 19. So, usually they're going to coincide. If an action would not be valid due to some sort of lack of quorum, you're probably also going to have some sort of open meetings violation. Maybe not necessarily. I mean, there's all kinds of weird scenarios you can come up with. But I think, again, the idea here is just that, and I guess I haven't said this yet, but we're talking about the opinion of one attorney, other attorneys, a bunch of guidance materials, all these other things. There's clearly some level of gray area when it comes to open meetings law. And I guess speaking more from just a policy perspective rather than just a strictly legal perspective, why would we want to operate in that gray area? Why wouldn't we want to do these things in a way that we can all agree is in compliance? Move that needle a little bit this way. I've been accused of being a real stickler on this stuff. Yep, I'll admit it. As I said, though, my job is to give you guys advice. And if you say, you know what, we'd like to start using some of these notices and saying the council may be present, I'll say, okay, that's your choice you're making. And there are arguments to be made to support that. But I think that there really is a way for us to satisfy everyone here. It's just going to be a little bit of an inconvenience. And if that's the price we pay for everybody to be happy that they can attend these things, then it's not that big of a price.
Should we go to somebody who hasn't spoken, or would you like to?
Let's start here, and then we can go to the other mayor.
Okay.
So, again, this is a sticky situation, goes back quite a ways. I know it's been suggested that we have alders have just kind of a roundtable discussion. I would love to do that. There are things that can come up in those discussions that wouldn't necessarily come up under an agenda item that one thought plays off of another. It would be great, but we can't do that. We have open meetings laws for a reason. We want to make sure that the public has the best understanding of what could happen. Having a couple people, alders, get together and talk about what they want on the next agenda or how they want to do things at Kubi's or Two Harps is one thing, but these meetings are much bigger. And I agree, I would love to have all of the alders at these meetings, but the advice of our city attorney, and you know what they say about attorneys, but our city attorney defends the city, represents the city. He doesn't defend the individual alders. You have your free will. You choose to do what you want, but he is there to advise you. But ultimately, his responsibility is to defend the city should something occur. That's why I use his opinion. Logan says that he's been called a stickler about those things. I've called him a stickler about those things, I think, maybe different words. because I'm trying to find a way to do this. But the advice that we've been given, and you can look it up, I'd be curious to know if there's any citations in regards to if there isn't a quorum present, if you can still continue the meeting, because over the years, and I know the former Mayor Halverson is going to speak to, well, maybe speak to one, he was there when we lost a quorum, and I wound up leaving because it appeared that they may have still been conducting business. There's things going on, Rhinelander, I don't know what's going on up there, but they have a couple of issues now. The one is the May 1st, they had a council meeting. The mayor canceled the meeting because they didn't have a quorum. They couldn't conduct business. And that's what I've been advised, both through the League of Municipalities, their city attorney, and other attorneys. Rhinelander also has one with a open meetings violation because 5 alders got together, and I don't know if it was at a bar or wherever, they got together and wrote a letter to the council president. All 5 of them signing it. That means you were conducting business outside of an open meeting, and that's a problem. One of the solutions that we've had, and as I said, if we list it as a council meeting and we have a quorum, great. Everything's fine, provided we meet those agenda guidelines. The university thing was a big deal because based on what I was advised, we had to stop business. That didn't mean the meeting had to stop. That means we could no longer have a quorum of alders there and quorum is the wrong word, the 6 or 7 that Logan was talking about couldn't be there. So we had to stop that. And the way that Alder Jennings is proposing, I think will work in a lot of cases. We can do a doodle poll, private doodle poll. You won't see who's able to and who's not, but the clerk can determine then if a quorum will attend, and then we can work with the city attorney to properly notice that meeting, but we have to then have the quorum there. My solution around that has been to record all of these things, and that will continue even if we solve this. Recording these gives the opportunity for anyone then to watch it. You're not able to participate, and Alder Jennings' memo talks about this, things like mannerisms and how you say things. It's important to be able to see that. You don't get that all the time with the camera, although our camera crews are phenomenal, and they do a very good job of getting those. It doesn't always happen, but it is a solution. I think Alder Jennings' solution would also work, provided that we can meet all of the statutory requirements that we have. But as Logan said earlier, his job is to advise. You interpret it how you want, but then you also have to defend that, and if Logan's asked why, he can speak to his own opinion, but I think the impression is that he will tell them what he has told us here and previously.
Just a really quick note, the meeting that happened at UWSP a couple of years ago has clearly become a psychological boogeyman for everybody in this context. I think if we would have just known ahead of time that Alderperson Doxtator had to go to work at a certain time, we could have announced, this meeting will have an ending time of X. And it was, I think, 2.5 hours or something that we got.
It was a tough meeting.
When you have a meeting that is information and discussion only about something that people really care about, it's easy for it to go forever and not have an ending point. So I think in that situation, certainly, and if there's ever a time in the future that we will have somebody who has a commitment where we might lose a quorum, just let everyone know. We can say, we're gonna have a great discussion, we're gonna end it at 8:30 or whatever it is. I think that, if everyone would have just known ahead of time, I don't think people would have been upset.
Yeah, that was very frustrating.
Mayor Halverson, did you want to add something? You know the drill.
We need you at the lectern, sir.
You know the drill.
Actually, this didn't exist when he was
Oh,
here.
it did not. Well then, name and
Andrew
address for
Halverson.
the record.
501 Wilshire Boulevard. I want to say very briefly, inconvenience is a very, very small price to pay for ensuring transparency and the elimination of any formal or informal assumption of secrecy. That is a very, very important role of government. That's it.
Alder Shore, wanted to make another comment.
Thank you. Still David Shore, still Second District Alder. So here's a situation that I think is likely to come up. If we put in a new system and the people who are interested in attending a meeting don't represent a quorum of the council, aren't even 6 or 7, but do represent a quorum of a committee. Fine. I suppose then you notice it as a meeting of that committee. subject, the topic of that meeting, may be, like totally mismatched with, whatever the committee is. And I guess that's just how that goes. Is that what I'm getting? Okay.
Alder Dalton.
I would just like to say that, reiterating the point that both Alder Jennings made in her memo and City Attorney made, that neither the city attorney nor the mayor is the boss of the council, that's the population, and we are responsible for governing our conduct. So when we're at these meetings, obviously, it's our responsibility to not be discussing things and being aware of what's going on, so it seems very simple and very standard to be noticing whether or not we are going to a meeting to the city clerk. It's not very inconvenient, we already know what's going on. And I think that while I think this memo brought up an important discussion, there's no formal action to be taken. So I think if we wish to formalize a policy about notifying, we will probably see a resolution, and I guess I would move to table this discussion. If that.
I don't know that do we need a motion?
We don't need a motion, but if,
I agree. I think we've probably looked at every angle at this point. What it comes down to, I think, is balancing the right or need to gather information with the intent of transparency in government and keeping the light of day on what we do as council members. So I think we can work together to figure out a way to make it easier for us to gather the information we need without running afoul of open meetings laws. So with that, I will adjourn at 8:15.
Videos of these meetings are available for viewing on the city's website, stevenspoint.com/videos.